Well, hard act to follow there, Michael. And remember, Michael set the topic here, so so I've reflected on that. I'll pick you up on your "Hey, Mike" from the students.
Yeah.
I know that's jarring, but when I actually raised that with one of my millennial students, they said, "Well, you guys, you old guys, you say dear so and so, and that is really creepy." To call people dear somebody, I mean, ugh, that's creepy. Hey is much more respectful and at a distance. So I don't object to hey so much anymore. And so that sort of, I think we as the older generation, need to sort of update our expectations on those kinds of things, which I wouldn't necessarily call ethical, but just sort of etiquette types of issues. Sure. When I sat down to think about your topic of teaching young lawyers and ethics in particular, and in a world of social media and new technology, I reflected that I think taking aside, the particular classes on professional ethics and how you manage your trust accounts and communications with clients and fee disclosures and all that sort of technical stuff, I actually think that whether we are aware of it or not, those of us who are embedded in teaching young lawyers about our legal system are always teaching an ethical framework. And I think we're teaching them about the body of ethics that inform our society, that inform the institutions and the practices that we as a rule of law-based society depend upon, in the way that, and we sometimes, it's invisible to us. It's sort of like the water around fish. Sometimes I think fish don't really realise they're swimming in water. We're actually swimming in a system that depends upon these fundamental ethical principles that really need to be observed regularly. Now, I'm thinking of those fundamental principles like, the golden thread of English justice in the criminal law system, that in the criminal law system a person is innocent until proven guilty. I think in the modern age there is a temptation to leap. Well, the newspaper said that somebody did something. The mere fact that they put the word alleged in there, it protects them from defamation, but there's always the assumption, oh, well, somebody must have done whatever it was said. And this leaping on, getting outraged very rapidly. I think as lawyers teaching law students, one of the things we teach is for students to suspend judgment until such time as they've assessed the evidence, particularly when we're talking about criminal kinds of matters. I think we teach also sound administrative law principles are ethical principles, the principle of hearing the other side before we reach judgment, of acting without prejudice, of removing ourselves as a decision maker if we recognise that we actually have a conflict between our personal interest and our professional duty, that we have a commitment to the truth, regardless of our own preferences or concerns, regardless of sometimes even of our own needs. And this is something that when we're talking to students, they need to understand that often their obligation, notwithstanding that they would like to be acting for a client and make sure the client wins, if they become aware of matter that's contrary to their client's argument, their greater duty is in fact to the court, if it's a court matter, or to the system as a whole, that they can't use tricky strategies to win an argument as if it's just a school debate, when the truth is what our ultimate goal is. And I think they're really important ethical precepts because they ensure that the decisions that we make are based on reliable evidence after an impartial inquiry that does not discriminate against people on irrelevant grounds. I think at the heart of those ethical principles is a respect for open and rational inquiry. And it's at this point I'd like to just tell you a brief story of a reminder of why I think it's really quite necessary to remember these things. About this time last year, or maybe it was a little bit later in the year, I found myself in the awkward position of having to defend the Sydney Law School's curriculum against an attack by the Daily Telegraph. Now, I don't have that much to do with the Daily Telegraph in usual circumstances. They don't tend to be, our students don't tend to be Telegraph readers necessarily, but nevertheless, what happened here was somehow some young chap from the Daily Telegraph got wind of two subjects on our curriculum. One of them was Introduction to Islamic Law, and the other one was Muslim minorities and the law. The first one, I'll tell you, was a very pragmatic subject, about 50% of which was in fact a commercial law subject on Islamic banking practices. And given the number of countries around the world who are important trade partners of Australia, it's quite common for our more commercially focused students to want to study what the banking and finance and commercial principles are in those jurisdictions. And as you'll be aware, there can be particular rules in a system that's based on Sharia law in those areas. So half that causes, in fact, a very dry commercial subject. The other subject is more what we would call a jurisprudential or theoretical subject, which really reflects on critical perspectives on our law and our legal system. When does our law and our legal system in fact fail to do justice because it discriminates against certain groups? And there's quite an interesting study in the book that this new course was based on of some of the more Islamophobic elements even in our justice system. So an opening up, a critical perspective on what we even do as lawyers. Both very interesting units of study. The first one actually available to study overseas in Southeast Asia. The second one, a jurisprudence subject available only to our master's students. Now, that's not just a sales pitch for the curriculum at the University of Sydney. That's just to make sure you realise that you don't make the mistake that the young Telegraph journalist did of thinking that what we really must be doing here is we must, at the University of Sydney Law School, the school that Tony Abbott went to, the school that produced Malcolm Turnbull and John Howard and Gough Whitlam, that we are in fact training terrorists. Nothing, of course, could be further from the truth. We answered the Daily Telegraph's initial inquiries by explaining the nature of the subjects and why we teach these in our curriculum, and we also teach all sorts of other comparative law subjects to make sure that the best and brightest law graduates in this state have an opportunity, have a very full, open, rational legal education. They didn't really publish terribly many of my comments. They tended to focus on the shock and horror of the training terrorists. Now, that disappointed me, but I wasn't all that surprised because I do know what the Daily Telegraph is like. What disappointed me more was that some other media outlets picked up the story, and I actually discovered this. I discovered I needed to look at the front page of the Telegraph because I'd seen on breakfast TV David Koch saying, "Oh yes, this is ridiculous. Our Sydney Law School teaching these subjects. And I'm thinking, what? David Koch believed what he read in the Daily Telegraph. Now that really disappointed me because again, those people didn't come back to us and say, "Okay, what's actually going on here? Here's a little bit of possible evidence. Can we test that and see what the truth is here?" That disappointed me. What disappointed me even more was the follow-up story on the Sunday Telegraph, where a Minister of the Crown, indeed Simon Birmingham, the one who was supposed to be leading educational policy in this country, was also buying into the debate and also went on record criticising us for engaging in religious education. Again, it would have been very simple for us to just send him a copy of the unit of study guide and he could have seen precisely what was in that subject. No, but still, perhaps, ill-advisedly allows his voice to go out there, chastising us again. So that was pretty upsetting. The next thing that upset me, but frankly didn't surprise me, given the recent experience I've had in this role as Dean of Sydney Law School, was a whole raft of people began sending me hate mail. Not our students. Our students didn't mind having a broad liberal education. Not people who were our alumni even, because they'd been to Sydney Law School and they had a fair idea that our subjects were not likely to be nearly as interesting as they were being alleged to be in the Daily Telegraph. But from people who had absolutely no personal or legitimate interest in what we did at all. They just wanted to get angry. And I got all sorts of stuff in the emails. The really interesting thing was a whole lot of people who were obviously deeply religiously committed themselves started sending me messages saying we should, instead of teaching Islamic law, we should be inculcating students in the Judeo-Christian ethic. I found myself having to go back to those people, and notwithstanding that myself I am a communicant member of St Mary's at Darling Street, Balmain East. So I don't say this as a person who is an agnostic or an atheist, but I don't believe it is the job of a law school to teach religion, and we don't teach religion. I suspect that some of the people who attacked me don't know even as much about Christianity and certainly the versions of the Bible that I'm familiar with than I do, given some of the things that they would say. But I don't think that teaching ethics to law students has anything to do with teaching religion or religious-based rules of morality. I think, in fact, our own legal system, our own rule of law-based legal system, in fact, has in many ways a purer form of ethics that's quite safe for any religious faith to adopt. It requires that we hear the other side, that we suspend judgment until the evidence has been weighed and tested, that we treat all people as equal under the law. We engage in no discrimination on irrelevant grounds, including faith-based grounds. We abide by standards of absolute transparency and honesty. All of those ethical principles that are embedded in our legal system are compatible with the kinds of faiths that I have any familiar with. It was interesting too that among the hate mail I got quite a lot of regular mail that went on for months from a Malaysian-based gay rights activist who assumed that if we were teaching a course in Islamic law, that must mean that we were preaching homophobia at the law school. Again, nothing could be further from the truth. It was another assumption based on ignorance, another assumption based on a lack of any effort to interrogate the evidence. And it demonstrated to me some of the hateful harangue I got around this issue, when I've had hateful harangue around other issues as well. It showed me that a lot of people seem to have an ingrained desire for inflaming, passionate, emotional arguments. That those of us who actually crave peace and a harmonious, tolerant society seem to be in the minority. Why do I feel that now in ways that I didn't necessarily feel 20 or 25 years ago? Because before, all of that bile wasn't in my face all the time, and that's where the technology comes in. The trouble with social media, the trouble with Instagram and Twitter and everything else that can spurt out a response immediately, is that it permits people to act irrationally and precipitately and on the spur of the hateful moment. What we need as law teachers to teach our students to do is, notwithstanding that they're wonderfully passionate, firebrands for very important causes often, we need to encourage them to shut up until they've interrogated the evidence, to listen to the other side, to refrain from leaping into battle until they've taken those steps first, to think about the implications of their decisions and their actions, to think from the perspective of the other, or the many others, the potential others who might be hurt by their actions. The temptation of the social media, of course, is to dive in first without thinking carefully, and I think we need to encourage them to slow down their response rates to enable them time for rational thought rather than emotional response, to give the brain a chance to override, the heart and the stomach on occasions. Now, I don't think those values and those objectives belong exclusively to any particular faith. I think they're consistent with all good, solid, well-based moral faiths, and they're certainly consistent with scientific rationalism, and those are the values that I would continue to advocate being taught in law schools in this country.